Hey guys, so by special request, this is just a quick video to talk about the calendar control order that was filed in the Fairfax County Circuit Court on August the 30th. And it reflects that Amber Heard has requested argument on an interlocutory appeal in the Johnny Depp defamation case. I wanted to do a quick video because I did discuss this briefly at the end of my last one. You'll recall I talked about how the standard is pretty demanding for that, and I didn't expect that she would be successful, but that she might try. And so lo and behold, it does look like she is going to make that effort. So I thought I'd just take this opportunity to do a little bit deeper dive into what she's going to need to show and what the process is going to look like. So first off, I want to go ahead and pull up the order that this is all going to be based on. And so as you'll see, this is a calendar control order. These are things that are typically issued by a clerk or some other type of administrator in a court. They usually deal with scheduling matters or similar administrative types of issues. And so what this shows is that the action that's been requested is argument for interlocutory appeal. Johnny Depp is objecting to the hearing, but it is going to be granted. And so the court has also set a briefing schedule for Amber Heard to file her briefing essentially by September the 8th. Johnny Depp will have a response due by September 29th, and then Amber Heard can reply on October the 6th. The actual hearing on this will be October the 12th, and as we know, frequently with these types of hearings, we may not get a decision immediately. It may be something that is decided later, either in a memorandum type of decision or a written order. I will go ahead and as we go through what the court is going to be looking at in making this decision on the interlocutory appeal, I'll go ahead and give you my thoughts about what that's likely to look like in terms of the time frame for a decision. So I want to go ahead now and pull up what it is that Amber Heard is going to have to show to get what she's asking for. So just to recap, you will remember that the interlocutory appeal is not normal. What interlocutory means is that it's being done before the entire case is done and resolved. Normally appeals wait until the end of everything, but an interlocutory appeal is a situation where, for whatever reason, people think this is a decision that is important enough that it needs to be decided before the case goes forward. So this is the standard here. It's in part of the Virginia Civil Code, and it basically describes the standard and the procedure for this type of thing to happen. So basically what it says is that any party can request in a civil case that a circuit court certify an order that it has issued for interlocutory appeal. And so what that means is that Amber Heard has to first ask Judge Azcarate to certify her ruling on the plea and bar as appropriate for interlocutory appeal. What happens then, this is in the third paragraph of the statute, if she got that certification from Judge Azcarate, she then has to file a petition in the Virginia Court of Appeals requesting that essentially they review that certification. They get to decide independently if they agree that it has merit or not, and then exercise their discretion to decide whether they want to take it or not. Interlocutory appeals are always discretionary. There's a very few limited exceptions to that, but by and large, it's almost never a situation where the Court of Appeals has to go along with it. They will do it if they think that it's appropriate. So in terms of whether it's appropriate, the standard is here in the second paragraph. And there's 4 elements that Amber Heard is going to have to show in order to get that certification from Judge Azcarate. So the first is that the judge's ruling involves a question of law, and that one, there's a substantial ground for a difference of opinion. Two, there is no clear controlling precedent on point in the decisions of the presidential courts, the Court of Appeals and the Supreme Court of Virginia. Three, that determination of the issues will be dispositive of a material aspect of the proceeding currently pending before the court. And four, it's in the party's best interest to seek an interlocutory appeal. So the third standard is the only one that's really kind of a given. It was a dispositive motion because it would have, had Judge Azcarate granted it, it would have precluded a trial in Virginia, basically adopting the judgment of the UK court and saying, hey, this issue's already been resolved, so we're not going to litigate it a second time here in Virginia. Obviously, Judge Azcarate did not rule that way, so the case is going to go forward. But because the decision potentially could have terminated the case, that third element is the one that's going to be easy to meet. The fourth, it's in the party's best interest. That's kind of always a matter of personal opinion. On the one hand, of course, a lot of us think that, hey, it's Johnny Depp, you know, it's in his interest to have a full and fair trial in the state of Virginia on the merits of his claims, where he can have the full tools available to him to investigate and impeach Amber Heard on the claims that she has made. On the other hand, there's always concerns of judicial efficiency in these types of situations. Courts don't want to have unnecessary trials. And so the point is that it saves everybody a lot of expense and trouble if this is a situation where, hey, that ruling would probably be reversed on appeal. So why would we go through the whole expense and inconvenience of a jury trial, which is, you know, projected to take 3 to 4 weeks or so, when we could just go ahead and have the Court of Appeals you know, look at it now. So that issue tends to be relatively related to the merits of the request. Basically, if it looks like a real strong case that the ruling is going to be reversed, it's going to be far more likely that the judge would find, yeah, it's going to be in everybody's interest for us to go ahead and deal with this now. Where Amber Heard is going to have trouble is with these first two elements, that there's a substantial ground for difference of opinion and that there's no clear controlling precedent on the issue. So this just goes back to the merits of her request to dismiss the claim that I have discussed before and went over the basis for the ruling in my last video. Essentially, there's really not a whole lot of ground for a difference of opinion on this one. Amber Heard struggled to find really any case law that would support her position. The judge noted in her memorandum those things like how it was very peculiar of her to raise, for example, the res judicata issue because the subject matter of the Virginia lawsuit was so obviously different than the subject matter of the UK lawsuit. They involved different publications, different statements, different claims by different parties. So the fact that she had to, you know, reach to the extent that she did to even really come up with an argument does not really bode well for her being able to show that this is really an issue where a lot of people are going to have a difference of opinion. Now, granted, Judge Azcarate did not find it sanctionable. So she didn't think it was so far out there that it was completely lacking in merit as to be frivolous. But that said, it was clear from the tone and the substance of her opinion that she really thought the law was pretty definitive. At one point, she made a statement that this is not an issue of first impression. This is an issue of stare decisis. Stare decisis is the legal principle that what has already been decided is going to continue to apply in the future, so that there's consistency in the legal rules and the expectation that people have about the actions that the court will take on any particular subject. So in this particular case, really all of the case law pointed in just one direction, and that was in favor of Johnny Depp's position. Same issue really with the second element, that there's no clear controlling precedent on point. That goes directly to Judge Azcarati's statement about stare decisis. There's a lot of law on collateral estoppel, on mutuality, the mutuality requirement, the same parties or in privity with the same parties requirement. So this is not a novel issue that Amber Heard was trying to raise. She just wanted the court to essentially decide that those were bad rulings for whatever reason, and based on that to allow her to preclude the Virginia trial. But obviously that's not the same thing as there is actually no law on the issue. There is a lot of law on the issue. Amber Heard just didn't like that the law compelled the outcome that it did. So for those reasons, I don't think she's likely to meet those first two standards. And because of that, I think that it's highly unlikely that Judge Azcarati is going to grant the certification. So if Judge Azcarati does not grant the certification, then that's the end of it. She's got to wait until the end of trial. Then she would be able to raise this issue on a final appeal. But at that point, she would not have any basis to go forward to the Court of Appeals at this time. If she did get the certification, then the statute does allow for Judge Azcarati or the Court of Appeals to stay the trial if they think that it's, basically prudent to do so while they take up the issue. Barring a petition to the Court of Appeals, that's not going to be on the table. So this hearing on the 12th essentially is all about Judge Azcarati's certification. It's the first step in that process. It's the first hurdle that she would have to clear to get the stay, to get the appeal, and to essentially put the brakes on the discovery process that is proving to be so damaging to her. I think that's about it, guys. The last thing I just wanted to mention was, because this is not really a complicated legal question, it's going to be fairly straightforward, I think, in terms of whether these elements are met or not. I do expect that the decision will be made rather quickly. It could be done on the day of the hearing, which is more typical for decisions that are kind of more straightforward and more discretionary in their application than things like the ruling on the plea and bar that require a lot of exhaustive legal research and analysis. In those types of situations, it benefits the judge and it benefits the parties for the decision-making, the rationale for that decision to be clearly laid out in writing for everybody's benefit. With something like this, because this decision in and of itself is not going to be appealable, it's not going to really be a basis for any type of claim of relief if it's denied, those same types of incentives are not really at play here. So I do expect that Judge Azcarati will have a quick turnaround on this decision. So that's it for the interlocutory appeal, guys. I haven't changed my opinion. I still think it's really unlikely to go forward. I don't think she's going to clear that first hurdle. And certainly if she did, even if Judge Azcarati gave her the full benefit of the doubt, I expect that the Court of Appeals is going to look at this with raised eyebrows, rather like I did when I first saw the argument. So we'll go ahead and keep our eyes on this. If anybody has any questions, feel free to leave them in the comments, and I will do my best to address them in a future video. And in the meantime, once the briefing starts to come in, I will follow up on that as well. So take care, guys, and hang in there. See you soon.